Good evening, and welcome again to Public Perspective. I'm your host, Kevin McDermott, and tonight we'll be talking about some interesting issues that you may not think about much, but that affect you. Things like privacy, criminal justice reform, and other issues. Our guest tonight is Ed Yohnka, who is the Director for Communications and Public Policy at the American Civil Liberties Union here in Chicago. Ed, thank you so much for coming back on the show.
Well, it's great to be here, Kevin. It's nice to be with you and to be back here on your show.
Yeah, well, so let's, it's been a while, so let's catch up on what's happening in the world since the last time.
Very little in terms of civil liberties, you know.
Oh, I'm sure.
We're making very little progress, or so it seems.
Oh, it's Martin Luther King, the arc of history is long, but it bends towards justice.
That's,
So.
you know, we as public policy advocates use that phrase as much as possible because it explains why it's taking us so long to actually achieve the things we set out to do.
Yeah, but eventually, as you know, over the period of many years, things do happen. I mean, look at women's suffrage. How many decades did that take before the vote actually happened? But it did. And only through the efforts of people like, or groups like the ACLU, do those things continue to move forward. So, never think that your efforts go unrewarded.
Well, you know, I think it's interesting in all of this sort of work. You know, you're right. I remember, and I've told this story often, 4 or 5 years ago, or maybe a little bit more, I went down to Carbondale and met with a couple who were ultimately plaintiffs in our lawsuit challenging the freedom to marry for same-sex couples in Illinois. And I said to them, this will be a long journey. We'll go through a lot of ups and downs because we knew that we would start litigation and there'd probably be a legislative effort as well. And what was fascinating was, the day that the bill passed in Springfield, they called me on the way home, this couple in particular, and said, you always said it would be up and down and that there'd be, these steps in the road. And I think what you do is always see if, whether it's issues like that or others, that you can always mark or define some sort of progress as you move along. That's really what the journey is all about.
And that's a particular journey that went much faster than people would have thought. The idea that same-sex couples could marry. If you talked about that even 10 years ago, people would have told you that was a total pipe dream. And now here it's basically the law of the land.
It is the law of the land. And what's, I think, even more fascinating, Kevin, is that, not only did that go faster than people anticipated, and you're right, I think once we saw, after the Windsor decision in the Supreme Court that had to do with the Defense of Marriage Act, and, once you sort of knock down those provisions, there was this sense of momentum that began to build all across the country. And I think what was really interesting and telling was that as it did, you also saw support for the freedom to marry grow exponentially. So, whereas at the time of the Windsor decision, I remember seeing some of our polling in Illinois, running at 42 to 44 to 45%, and almost instantly that jumped up over 50, and it told us that the legislative solution was possible. And so I think that, that's one of those times when, in fact, it may well have been always that the voters and the public were way ahead of where policymakers actually were.
Well,
and I think that's the other truth that we often see in this work.
I think that's really often the case. In fact, there's a cliche about politicians that they don't lead, they just step in front of movements that's already going.
Right.
So along that line, though, of same-sex marriage, we're seeing now the rise of so-called religious liberty laws.
Right.
Indiana and other states where these things are coming out. And I'm sure the ACLU is playing a role in those as well.
Yes. In fact, on a number of these, we've played a key legislative role in some states opposing them, worked with governors, worked with others in other states in opposition, brought lawsuits. The rather far-reaching, sweeping bill that was recently passed in North Carolina, we filed a challenge to that legally within a few days. In Illinois, we actually just this week had a development in a case that goes back, as we think about the sweep of this, that actually goes back to 2013 or 2011, forgive me, and the start of civil unions. So we have a downstate couple from where at the time they lived in Mattoon, Illinois, just south of Champaign, a couple, Todd and Mark Wathen, who after civil unions were made available decided they wanted to have a civil union ceremony. They wanted their family members to be a part of it. And so they looked around knowing they had family members coming from Missouri and from Kentucky, and they wanted something that was essentially in the lower half of the state. And they looked around in a number of places, and they found a bed and breakfast that offered civil wedding ceremonies. So they presume that would have applied
Covered
then
to
to
civil
civil unions in Paxton, Illinois. And they reached out via email to the owner and said, we're thinking of having a civil union ceremony. And they were told that the bed and breakfast owner would never host a civil union ceremony because he had a religious objection. And that not only that, but then the owner proceeded over the next couple of days, unsolicited, to send our clients emails suggesting to them that their lifestyle was, quote, vile, and that they had time to repent. Ultimately, we brought an action in the before the Illinois Human Rights Commission about this because it's a violation of public accommodation, and it underscores this point. The bed and breakfast owner has every right to his religious beliefs, and as the ACLU, and I think as a civil libertarian, I would always defend that. I think it's incredibly important. The problem is that you can't take those beliefs and apply them to a public accommodation, to a business. When you put your shingle out and when you open the door, you say that you are going to welcome everyone who comes to your facility, and you aren't going to judge them or deny them services on the basis of certain protected classes. As the matter of fact, just historically, this was one of the great claims that we saw during the civil rights era in the South, was that after lunch counters, for example, were going to be integrated, business owners would say, well, I can't have African Americans and whites sitting together because my religion tells me that's wrong. And they would attempt to use
the same exact argument.
Same exact argument. We saw the same argument about people trying to avoid participation in the Social Security system. And we've seen the same argument over the years in terms of equal pay, with the claim that, I believe that the man is the head of the household, therefore I'm going to pay men twice as much as I pay women for equal work. And so
even if this is a private company,
if they're performing a public service, if they're a restaurant, a hotel, if you're a doctor, once you put out your shingle and you say we're open to all, then you have to take everybody. Now you can have a private club that can exclude, but in that instance, then you can't open your services up to everybody else. So in this case with the bed and breakfast, when we brought that challenge, it took a lot of years to bump through the process, but last summer, the commission ruled that it was in fact a violation of our clients' rights, and then we got a damages award this week from the commission for this, and it is, I think, exemplary of many ways of the fact that these arguments do come back. I mean, these religious liberty arguments that we're hearing today, as I say, were the same ones we heard about women when women began to gain equal footing in society with men. We've heard it about African Americans in the civil rights movement, and we're hearing it today about gay and lesbian couples. These things are cyclical, and I think we go through them periodically. But I think the most important thing is to continue to, really sort of point out the principled position, which is that while you can have your religious views, you can't use your religious views in order to discriminate against another. And that's really the notion that we have to continue to defend.
And now, the case that just, I guess, is either just being decided or won't be decided because of the 4-4 split on the Supreme Court about the religious organizations, the nuns having to provide birth control that they don't believe in religiously. So there's a case that seems very interesting. So it is a religious order where they want to, they exist in order to follow their religious beliefs.
Right.
How do those play? I mean, what are the issues there?
Well, that case is really, I think, interesting because the question there is not whether or not they have to provide the order or other religiously affiliated institutions have to provide a product that they find religiously objectionable in contraception. But whether or not the simple act, because what the government did was they said, we understand that you find that religiously objectionable. If you do, then the process you have to go through is you have to fill out this form and send it to us and tell us you don't want to do it, in which case the private insurance company will provide the service to your employees at their charge. And that's the process.
So you as the religious order are out of the picture.
You're out of the picture. What the religious orders are arguing, in effect, is that it is a violation of their religious liberty simply to have to fill out a form and declare it. That's really what's at issue in that case. They were at, what happened, in fact, just this week, is that the court issued after the argument or asked for some additional briefing from the parties, in which they said, well, if this isn't the process that would work, what would? What would be less intrusive? What would the plaintiffs think, was less in infringement upon their religious liberty? And I think it'd be fascinating to see what they come up with. If simply filling out a form, checking a box, and signing it, that's all they were asked to do, is objectionable, then I think we have then the question is, what is it that could be done?
And it's possible that they might come back with something that might be acceptable. We don't know.
It
right?
is possible. I will say that at the time that this issue grew up, after the adoption of Obamacare, the administration spent a lot of time and a lot of energy meeting with these groups and trying to find out what would be the procedure that would meet their objections. And I think that one of the things the government would say is that we really did try to meet them more than halfway with this process, but that in point of fact they weren't allowed to. There is some speculation in Washington now that the effort to get this additional information may indicate that we aren't headed for a 4-4 split. That in fact what's happened is that Justice Kennedy may be going over with what has been called the liberal the liberal justices in striking that down as not being burdensome, and that the conservatives may be looking for additional processes to try to bring him back over. I think some people speculate the other way, and of course we'd all go broke if we tried to bet on what the court was going to do with something like this. But I think that it really is, it's really critical, because one of the things that's happening here is the question of, these are religiously affiliated institutions that are private. That's fair. The problem is they often employ people who are not of their religious affiliation, who have a right, for example, as part of their employment, to a health care package that includes all kinds of things, including contraception, which is for many women a critical medical necessity, even beyond the contraceptive value.
And by the way, it's not just for single people. I mean, married
absolutely
people.
Not married people as well. And again, many contraceptives are prescribed not simply for purposes of preventing pregnancy, but for a range of other conditions that have nothing to do with pregnancy prevention. So the reality is that these entities often function in a way where in the hospital case they use federal dollars through Medicaid and Medicare and otherwise to function. They have roads and tax benefits and other things that are developed so that these companies can flourish. And the question is, can they then come back really and say it's too much of an intrusion upon our religious rights simply to be able to sign a form? And I think it'll be a fascinating decision when it comes out to see how the justices, in fact, end up wrestling with just that question.
And if it ends up as a 4-4 tie, then they have to fill out the form, right?
Right, because in the case that came up, although this is where this gets a little bit complicated in a couple different ways. If the case that actually went up, the appellate court ruled in favor of the government and said it wasn't an intrusion. But there was a split in the circuits. So in point of fact, we could end up with this kind of hodgepodge of rulings where one circuit would be controlled by a decision that says it is a burden, and another circuit controlled by a decision that says it's not. But because the 4-4 tie essentially sends it back down to the appellate court. And in these cases, there have been a number of these cases that have percolated up, and appellate courts have ruled differently. And that's where this gets incredibly complex. Right. The other reality of this, however, is that 4-4 decisions in the Supreme Court in a rare circumstance like this where either a justice, in this case there's a vacancy, or when a justice has to recuse themselves, have very little precedential value. So the reality is that there are still other cases that are working their way upward, and once the seat is filled, whenever that happens, you would anticipate that a now fully staffed Supreme Court would take that decision up, and there'd be a ruling on it, which would be definitive then at that point. But it makes for some very interesting days.
I'm sure it does, and court watchers are having a field day, I'm sure, trying to bet which way the wind will blow.
It's interesting, that case, and then, the recent case that was decided, having to do with union dues was, I think, one that people had closely followed.
Now, is that the same, though, because it was a 4-4 split? So does it revert back to the appellate?
It reverts back to the appellate court, and the appellate court had actually ruled in favor of the union. So, in fact,
other competing appellate decisions?
There actually weren't splits on that one in the courts of appeals across the country. So that was an issue.
That's a pretty clear-cut one.
That's a pretty clear-cut one at this point. What's interesting, and I find fascinating, is in the case, the Texas case regarding abortion regulations that had gone up, a Fifth Circuit. This is a case in which Texas passed a law that applied a number of regulations to clinics that provide abortion services.
That basically we're going to put them out of business.
It put the vast majority of them out of business. In fact, there is literally no abortion clinic in Texas that is west of San Antonio at this point. And even more of these clinics will go out of business if these regulations are upheld by the Supreme Court. And what is fascinating is Mississippi passed a similar law. So Texas, the Fifth Circuit, which includes includes Texas, upheld the Texas laws. And one of the things that the Fifth Circuit said was, in effect, well, it didn't really strike down, it didn't shut down all of the clinics in Texas. So therefore, it didn't put an undue burden on access to abortion care in Texas. Mississippi passes a similar law. Mississippi ends up closing the last abortion clinic in Mississippi as the result of this law. That goes up through a court of appeals, and the court of appeals says essentially, well, if you close down every clinic in the state, then it is an undue burden. So that's a case which, again, looks like it could result in a 4-4 tie as the result of the vacancy now at the Supreme Court.
Well, is that expected to make it up to the court in the time when that seat's likely to be vacant?
Well, the Texas case has already been argued, and in fact will be decided or is set to be decided this year. And so the question is that if that ends up being the case, then does the Mississippi case come up with a different set of facts and a court of appeals that in point of fact says, that there is an undue burden. And so it has created, I think, for people who, watch and monitor the activities inside the Supreme Court of the United States, it has just created a whole new sort of Kremlinology around trying to figure out what's going on.
Well, let's shift gears for a moment, because there's many things that the ACLU handles, and one of them is privacy. And you and I, before the show, talked about Stingray and what Stingray is and what it does and why it may be a real issue. So let's talk. Describe Stingray. What is it?
Yeah. So a Stingray is sort of the trade name that's used for something called a cell site simulator. So imagine, if you will, the cell tower that's, say, right around here that your or my smartphone pings off of in order to get service. What happens is police use these Stingrays or cell site simulators. They put them up in a particular location, and that tower simulates a cell tower, and it draws a signal from your phone, from my phone, and from everybody else's phone who's nearby.
So essentially, it becomes the cell tower.
So essentially, it mimics and becomes the cell tower. So there's
all your communications go through that Stingray device. All your communications
go through the Stingray device. And oftentimes, one of the things that happens is your service becomes very slow because usually these have a lower generation signal, and there's all sorts of issues. Your phone actually ends going up from there to ping off somewhere else to actually be able to be used. So the police use these for location tracking. If they're looking for someone and trying to figure out where that person is, they put one of these up and they can identify that person, because when your phone pings off of the tower, it sends a signal with a serial code, and that code is identified with your phone or my phone. Right, precisely. So one of the things is that these devices that I've just described are becoming more powerful as time goes on. And one of the things that device can now do is it can collect, it can be used to, say, for example, drain the battery on your phone. It can be used to...
So it could be directed to your specific phone.
Right. It can put malware on your phone so it can take over control. It can download your contacts. It can download your information. It can download the websites that you visited on your phone.
And this is all without a warrant.
Well, that's and that really is the issue. So I should just say, this is technology that was developed for the military. It was developed, really to be able to interdict and stop people using phones to set off IEDs in Afghanistan and Iraq. It's now been brought here for the purposes of surveillance, and literally it sort of grew up across the country without regulation. And one of the things is that law enforcement agencies, including the Illinois State Police, purchase these devices. They often purchase them using grant money from the federal government. And one of the things in the contract with the company that sold it to the ISP was that they had to agree that they would not publicly acknowledge that they owned it or used it.
Talk about lack of transparency. And these are federal dollars.
These are federal dollars. This is an agency in the ISP that uses our tax dollars, and yet we weren't told how or if or when they were using this device. So there's actually now, and what I was going to say is that in many instances we know that police and state's attorneys have sought warrants in order to use these, but it's not clear if that's happened in every case. So
and there's no regulation saying it must be the
There
case,
is no regulation at the state level right now saying there must be. I should say that last year, the Obama administration put in place some regulations for stingrays that are used by the Department of Justice, ATF, and the Department of Homeland Security. So in those instances, they have to get a warrant. They have to minimize the collection of data only to the person that they're actually trying to track. And if they sweep up any extra data, which of course they do whenever they use one of these, they have to delete that data as soon as possible and not store it.
Now, what protections, I mean, I understand the regulations, but what protections exist in order to guarantee that actually happens? I can tell you, oh, don't worry, man, we deleted it all.
Right.
And haven't done anything like that. So how do we guarantee that actually happens?
So one of the things they've done at the federal level is, the ombudsman for those agencies have specifically been charged with going back and reviewing the procedures each and every time one of these is used in order to ensure that the data is in fact deleted.
But who pays for the ombudsman?
Well, the ombudsman or the inspector general is an independent agent that acts within these agencies. And, to be sure, there is a level of trust here. There is a level of trust me that goes on. We're actually seeing in both the Illinois House and the Illinois Senate this year, there is legislation that would apply this these same sort of guidelines in Illinois. Because if you think about what I've just described, what this really means is that if the FBI uses a stingray in the Chicago area, they have to follow those rules. But if the Elmhurst Police Department did, there literally are no rules. And, our way of thinking about this is if it's good enough for the FBI and the Department of Homeland Security, it ought to be good enough for the Peoria Police.
Yeah.
And so we're very hopeful. In fact, law enforcement has kind of come around on this because the feds are using these things and have supported this bill in the end. And I think it will move through, and we have every confidence that the governor will sign it.
Well, now it begs the larger issue, though, of data privacy in general. And Stingray is just one of an ever-growing number of technologies that threaten to invade your privacy. Is it true? I mean, is it the ACLU's belief that we may as well just give up on privacy because you just can't fight this battle anymore?
I think it would be a shame to say just to give up. I think, in fact, where we are, if you think about it, we're a couple of years out from the revelations from Edward Snowden about the kind of surveillance that NSA was doing without any warrants and without any oversight, really. I think this is a time when we actually can have some discussions about these things. I think the recent kerfluffle between Apple and the FBI is an example where people tended, by and large, to come down on Apple's side. If you look at most public opinion polling.
But it's close.
It's close.
Yeah.
But I think what that suggests, Kevin, is that there's actually now an appetite and room for a dialogue. And one of the things, frankly, over the last 15 years is we have mouthed the words about balancing privacy and security, but candidly, we've really only done security. We've never tried to balance anything. And I think that's the thing that we have a chance to do now in a way. So I don't think it's lost, but boy, we're going to have to work at it to roll it back, because every single technology advancement, every single new device we have is, whether it's a phone, whether it's a pad, whether it's a watch, whether it's whatever, is really just another device that can surveil us in the end.
Well, in fact, one of the great fears I hear voiced about the smart house is that everything, your television, your refrigerator, your thermostat, will be spying on you.
Right.
And you can't say anything in the privacy of your home without someone being able to listen in.
When you think about it, there is spyware that can be attached to, especially these devices, whether it's your iPad, your phone, your computer, that have a camera that can actually use it to switch it on and monitor what you're doing
remotely without
you knowing it. And I think all of those kinds of things really are reflective of a kind of a power that we're all putting in our homes, that we're all putting in our hands because we want the ease. What we need to do is to figure out regulations that sort of protect us as we go forward. There's a great stat on this that I always love and I always like to say, and I probably have said it too much, but the last time that the United States Congress actually updated our online privacy laws, Ronald Reagan was president, and few of us had a computer in our home, let alone one in our pocket. And so, it just shows you how behind we are where this is concerned.
Well, that's always going to be true. Legislation is a slow and deliberate process. Technology is breakneck, and we all talk about internet speed.
Right.
So it's hard for me to see how legislation can keep up with technology. So is there some other solution? Can consumers take the lead here?
Well, consumers can do a lot, and I think part of that comes really in terms of educating oneself, in terms of understanding where these fault lines are and figuring those out.
I hate to have thrown you that question when we have 15 seconds left. So can you say something in 10 seconds that would sum it up?
I would say that you have to learn what it is you're doing and find ways on your own to protect yourself as much as you can.
Great way to sum it up. Ed's, pleasure to have you. Thanks again for being here.
Thank you so much, Kevin.
And thank you for joining us once again on Public Perspective. I'm your host, Kevin McDermott. You can find us every Saturday night at 8 on Comcast Channel 19, and check us out on the web at publicperspective.tv. So until next time, thank you and good night. So